Olá, eu sou Jorge Pinheiro Castelo, presidente da Comissão de Direito e Trabalho da OAB de São Paulo. Estamos aqui para mais um evento de Direito Internacional promovido pela Comissão de Direito e Trabalho, coadjuvada por seus coordenadores, o professor Freitas e a professora Adriana Calvo. Entrevistaremos o professor Augustus, da Geórgia, professor de Direito americano, que vai tratar de 3 temas fundamentais para a comunidade jurídica brasileira. A questão do assédio sexual no ambiente de trabalho, o entendimento da Suprema Corte Americana em relação a esse tema, inclusive a partir do movimento Me Too, e a questão do assédio moral no ambiente de trabalho, também o entendimento das cortes e da legislação americana. E o terceiro tema fundamental, que é a questão da natureza jurídica da prestação de serviço dos trabalhadores por aplicativo. Portanto, acho que são temas importantíssimos que vão ser abordados agora nessa relevante entrevista. Boa entrevista a todos, espero que tenham um bom proveito. Muito obrigado.
We have a great honor and a pleasure, a delightful pleasure to receive here Professor Augustus Bonner Cochran III, or simply Professor Gus. He is from the Agnes College on Georgia, and he's visiting Brazil in different universities, and currently he's going to lecture at the University of São Paulo School of Law. And it's a pleasure to be able to be here with you, colleagues from the Bar Association, São Paulo State Bar Association.
So nice talking to you, and it's a pleasure to me to be here and help us with this interview. Gus, how is sexual harassment defined in U.S.?
Sexual harassment is words or actions because of sex that are sufficiently abusive to affect the working conditions. I think one point that's important to understand is that to be illegal, sexual harassment has to be much more severe or pervasive than merely offensive. It does not have to involve economic loss. It can be an abusive or offensive work environment, and it does not have to result in psychological harm to the victim, but it has to be objectively abusive. A reasonable person would find it objectionable, and also subjectively abusive. The victim has to really find it abusive herself.
Can you give us an example?
Yes, there are many cases where there were offensively obscene posters posted in the workplace, jokes, bad language, but the courts said this was not sufficiently severe or pervasive to be an illegal instance of sexual harassment.
And what is the difference between sexual harassment and hostile environment?
Quid pro quo harassment is when sexual favors are demanded in return for favors or favorable treatment in the workplace, or when some punishment is given because of the refusal to give sexual favors. The other type of sexual harassment is hostile environment sexual harassment. This is when actions or words create an atmosphere that is abusive, intimidating, or offensive enough to affect the working conditions of the work.
And in U.S., is there a criminal type of sexual harassment?
No, not as sexual harassment per se. Some types of sexually harassing conduct could be criminal, but they would be categorized as a different type of an offense. For example, a battery.
Gus, can you explain to us the importance of the precedent foreign elected in U.S. in sexual harassment cases?
The biggest issue in a sexual harassment lawsuit is whether or not the employer will be held liable, because the employer, not the actual harasser, the employer may have to pay money damages or reinstate the victim. The harasser can do neither. So the first case that went to the Supreme Court that made sexual harassment illegal, because we have no statute against sexual harassment, the Supreme Court did not make a clear decision. They fez zigue-zague. Only 12 years later did the Supreme Court make a clear rule. It is called Farragut, or sometimes Farragut-Ellerth, because that's the name of the case. It is a very complicated rule, but the employers wanted a rule that held them liable only for negligence. Negligence would be only if the employer knew about the harassment and failed to prevent it. The plaintiffs wanted a rule of strict liability or objective responsibility. So the Supreme Court made a complicated rule. If the sexual harassment resulted in a tangible employment action, tangible employment action means some significant concrete change was made in the employment. The victim was discharged, demoted, her salary was cut, etc. If a tangible employment action was taken, then the employer is objectively responsible, strictly liable. If there was no tangible employment action taken, the employer is still objectively responsible unless the employer can prove two affirmative defenses. One, that the employer took responsible care to prevent the harassment. The second is that the victim, the plaintiff, failed to take advantage of the preventative measures offered by the employer.
If the employer exercised reasonable care to prevent and promptly correct harassment behavior, could the employer be not liable for a sexual harassment case?
In fact, the employer must prove more than he was not negligent. He must prove both of these prongs, both defenses, and the burden of proof is on the employer.
Okay, Professor Gus. We are very interested in hearing from you to what extent the Me Too movement challenged the patterns of the American courts regarding moral and sexual harassment.
I think Me Too has raised awareness of sexual harassment greatly. Within the first day when hashtag Me Too was created, there were 4.5 million posts on Facebook of people saying, this has happened to me, or I have great sympathy. It has also, I think, showed that the law has certain flaws that have made it unable to stop this huge social problem.
Yes, I think still regarding the Me Too movement, would you say that the confidentiality in the settlement and the agreements would be, to a certain extent, also challenged by this by the movement? I mean, we have, from the Brazilian perspective, we see the American ADR system as a very successful, but we are very worried about to what extent this ADR settlements and procedures could avoid.
Yes, I think that's an excellent point. Because in some ways, I think the bad publicity is a bigger deterrent for many companies to prevent sexual harassment than the amount of the awards. In reality, the average settlement is only $30,000. And that sounds like a lot of money, but the lawyer must be paid, the expenses must be paid. It's really nothing. The main impact of Me Too may be to encourage victims to complain, because the reality is it is very difficult for sexual harassment victims to complain. We have a book by a law professor called Law versus Reality, because the law is going one way and reality lies in the other direction, because this Farragut rule requires that victims complain, use the procedures of complaint provided by the employer. But many victims find it very dangerous and demeaning to complain, and so they do not resort to the use of official complaint. They find themselves put on trial as to whether their behavior was reasonable or not. And so
Double victimization. It will be a double victimization.
it's a double victimization, exactly.
Try to benefit from your visit to the Bar Association and to move in order to address a different subject that is increasingly very interesting and debated here in Brazil. Is the California case, Dynamax, and the ABC test of classification, and most recently the approval of the Assembly Bill number 5, or AB5. Could you tell us, could you explain us a bit what is the importance of this precedent and how far this change in the state law could impact the subjects, like for instance the possibility of collective bargaining agreement?
So, to benefit from the protections of labor law, one has to be an employee. And this is a complicated matter because each law has a different definition, and many definitions are not at all helpful. They're tautological. For example, one law defines an employee as an individual who is employed by an employer. Therefore, courts have to fill in the gaps of these definitions with common law. And traditionally, the common law had a test that was very, very complicated. It had many factors that looked at who controls the work. And the courts do not privilege or give primacy to any one factor. So the law is inconsistent and very unpredictable. So some reformers advocate what is called an ABC test. And it looks at 3 prongs or factors. One is control, like the traditional test. A second is whether the work is outside the scope of the usual business of the enterprise. And the third is whether the worker is normally engaged in this occupation. But the real importance of this test is the presumption is that the worker is an employee unless the employer can prove otherwise.
Oh, Professor Gus, thank you very much for your kind visit to the São Paulo State Bar Association. I think we could benefit largely from your explanations, and thank you all. Thank you also, Professor Adriana Calvo, for joining us and being able to offer opportunity for the members of the São Paulo State Bar Association to have a bit more information about the North American experience, legal experience.
Então, agradeço a todos, agradeço ao professor Freitas e ao Gus, espero que todos que estejam aqui tenham apreciado a nossa entrevista.